Hello and welcome to another episode of Car Brief. I'm Richard Elslager and I'm an attorney in Chicagoland, and I have a particularly strong interest in all things automotive related. Part of my practice is devoted to personal injury law. I did a lot of defense work in my past, defending automotive cases or traffic related matters. I currently now do plaintiff work for personal injury, and also I handle various traffic-related offenses. That having been said, today's sordid little tale involves, you might have guessed it, by the coat that I'm wearing. It involves the Porsche company. And as you can tell, I'm wearing the Gulf colors, and those are the colors that were used at the movie Le Mans that starred Steve McQueen. He drove the Porsche 917, actually not to victory. He didn't want to win as an actor in this movie. The writer could never understand why, but I think McQueen was all about realism, and the hero doesn't always win. So he did not win in that movie. Spoiler alert, but spoiler alert from a movie that's well over 30 years old. So I'm sure if you're into cars, you may already have seen it and you know the result. That having been said, I'm going to don my driving gloves here to handle this sordid, sad little tale that involves the Porsche company in a case that comes out of California, the District Court of California more specifically. So let's get into this here. This is the case of Butler versus Porsche Cars North America, Inc., United States District Court for the Northern District of California, San Jose Division. It was decided on August 25th of 2016. So what do you think happened with Porsche? Think it might have been electrically involved, electronics? Maybe. I don't know what it is with the Germans and electronics, but it seems to give them a lot of trouble. I don't know why. How long have we been making cars, people? Over 100 years. We can't get it right, seriously. Especially the Germans. I mean, come on, the Germans, of all people. You're supposed to get this right the first time. In any event, plaintiff, Mr. Butler, brings the instant putative class action. This is actually a class action case. A small class action, a teeny-weeny one, though. Not nationwide, but confined to California. It's a class action case against the defendant, Porsche Cars of North America, for violation of the California Consumer Legal Remedies Act and California Unfair Competition Law, UCL. Before the court is the defendant's motion to dismiss the plaintiff's class action complaint. So typically what happens in a case when a lawsuit is filed, the defense attorneys tries to knock it out. They try to dismiss the case at the pleading stage. So if it gets dismissed at the pleading stage and it gets dismissed with prejudice, that ends the case completely. So you don't have to worry about juries making a decision, or if it's a bench trial, the judge rendered a decision. The case gets knocked out at the beginning. And this is a federal court case, so federal court, that having been said, there's a different pleading standard in federal court. Specifically, federal courts require notice pleading, which basically gives the parties a rough idea as to what the case is about. Whereas if you're in state court, Illinois, for example, they require fact pleading, which means you have to be very specific with your facts. If you're not specific with your facts, you're going to get a motion to dismiss filed against you. And that's not a good thing. So, but typically the courts will allow you to replead. They won't dismiss it with prejudice the first time. They allow you to have several bites of the apple. So that's what this is. That's what's going on in this specific case. They're trying to knock it out at the pleading stage. So plaintiff has filed a class action complaint. The defendant's saying, "Nah, I don't like your complaint. It's not well written. It's not well worded. It doesn't give us enough detail. It should be dismissed." So let's get into the factual background of this. The plaintiff lives in California and owns a 2007 Porsche 911 SC2 Cabriolet. Sounds like a nice car to me. Plaintiff asserts in opposition to the motion to dismiss filed by the defendants that the plaintiff purchased the car used from a Porsche authorized factory dealership on July 18th of 2015. So, in essence, the car is a used car. It's not bought as a brand new car right from the Porsche dealer. It's bought on a used car lot. It's specifically, I think it was a Porsche used car lot. So when the plaintiff got the car, it had approximately several hundred, well, specifically the case says that plaintiff's car had approximately 78,000 miles. and it doesn't say if that's what the mileage was when he purchased it, but it states that at that mileage, 78,000 miles, the plaintiff's key stuck in the car, and the car would not start. So I don't know how a key sticks in the car and you can't take it out. Maybe the tumblers. I think it's more of a modern type of key, so I don't think it involves tumblers. It's one of those that slots. It just fits into a slot in the dash, and then you give it a quick turn. Now they don't even have that anymore in a lot of cars. It's just it's a key fob, and it's all electronic. It's all by wire with a push start button, which is very race car oriented, I might add. It's kind of nice to the push button start. I like it's got a race ready feel to it. Even if you're in a regular Hyundai and you push the button, it feels like you're starting a race car, although it's not clearly, but the effect is that of starting a race car. In any event, let's get into it here. So the key stuck in the car, wouldn't start, and the plaintiff had the car inspected at a Porsche factory authorized dealership in Santa Clara, California. The mechanic determined that the problem was caused by a faulty wiring harness between the car's battery and alternator that caused the battery not to fully charge. Well, that's not a good thing. If the battery's not fully charging, it's not surprising that it won't start. So the mechanic replaced the harness and billed the plaintiff $3,180.44. Ooh, for the repair work and replacement parts. Plaintiff concedes that neither the plaintiff's car nor the car's wiring harness was covered by any express warranty at the time of the malfunction. So essentially the plaintiff's agreeing, well, it's out of warranty, it needed to be replaced, but it's a defect in the car nonetheless. So let's carry on here. The plaintiff alleges that the faulty wiring harness is a pervasive defect documented in the Porsche 997 class of vehicles across the country that appears to be attributable to a defect in the selection of material, gauge, or other characteristic of the wiring or harness between the alternator or battery that results in insufficient charging of the battery. So you know what's really going on here. It's Porsche cutting corners, theoretically, because they didn't decide on the merits of the case here other than the motion to dismiss, but theoretically they're cutting corners by using thinner gauge wire. Now I can tell you in the Mustang GT I had a 91 GT, and the fog lights had problems because apparently Ford used the equivalent of speaker wire for the fog lights. So they had problems going out as well because the wiring was just too thin. You can't use too thin a gauge of wire. Now, the flip side of the argument is, as the car ages, is the car manufacturer going to be held responsible down the road for defects in the car, or not necessarily defects, but things that go wrong? Because as you and I well know, wiring in cars goes bad after a certain period of time, and the resistance increases, and electricity just doesn't travel so well in the wiring harnesses because, well, the car is old and so is the wiring. But let's keep going here. The plaintiff alleges that the insufficient charging may result in the cars becoming disabled in the middle of a road or highway, or cause the car's headlights or other electrical equipment to fail in the evening or during rain. Well, tell me about it. I've had a problem with that car at night with the lights turning off after they get a little warm. So I'm going to be doing a rewiring on that. I'll probably put a relay in and a CV headlight system, which I already have. I'm just looking to put that in to avoid that problem in my own car. It's a little bit shocking when you're driving at night and your headlights go out, but they'll go back on once I turn them off and then pull them back on again and just basically limp my way back home. So I can certainly sympathize with that risk. The plaintiff alleges that Porsche has known all along about the existence of the alleged defect. So let's look into this a little further here. Plaintiff also says he cites to multiple message board postings from 2013 complaining about the faulty wiring harness, in that it's stated in the CAC, or the class action complaint. Plaintiff further alleges that Porsche discontinued the use of the defective wiring for all Porsche 997 vehicles following the 2007 model year. I wonder why they did that. But took no action with regard to the existing defective wiring in Porsche 997 vehicles with model years 2007 and earlier. Okay, procedurally, as I mentioned before, this case comes up on the plaintiff had filed their class action lawsuit on April 19th of 2016. And the plaintiff seeks to represent the class of all owners within California of the class of vehicles, where the class vehicles are defined as 2005 to 2008 Porsche 911 vehicles. Now, I like the Porsche 911. I was a fan of it growing up as a kid. I used to have pictures of it on my wall in my bedroom. So I didn't have the typical Lamborghini Countach. I had the Porsche, so I was a Porsche fan. But Countach is also a beautiful vehicle. Now let's take a look at the legal standards. So defendants, Porsche has filed a motion to dismiss. As I said before, they're trying to knock out the complaint at the beginning or at the pleading stage. So they rely on Rule 12b-6 of the Federal Rules of Civil Procedure, which requires the complaint to include a short and plain statement of the claim showing that the pleader is entitled to relief. A complaint that fails to meet this standard may be dismissed pursuant to 12b-6. And Rule 8a requires the plaintiff to plead enough facts to state a claim to relief that is plausible on its face. So there's our motion to dismiss, and the court has to rule on that motion to decide if this complaint is going to survive or if it's going to die, and it may die with prejudice, which means it's going to be dismissed and there will be no right to refile, or it may survive. Well, let's see what happens here. As far as Rule 9b goes, a claim sounding in fraud or mistake are subject to a heightened pleading requirement. So since the plaintiff in this class action indicated there's fraud involved on the part of Porsche, they have a higher standard to meet, so they have to have more detail in their pleading as a result. And the court made special note of this. So it requires that the plaintiff alleging fraud state with particularity the circumstances constituting the fraud. To satisfy the heightened standards under Rule 9b, the allegations must be specific enough to give the defendants notice of the particular misconduct which is alleged to constitute the fraud charged, so that they can defend against the charge and not just deny that they have done anything wrong. So thus, the claim sounding in fraud must allege an account of the time, place, and specific content of the false representations, as well as the identities of the parties to the misrepresentations. So the court goes on to address the CLRA claim. It's the claim that that's their initial cause of action. So what happens when a lawyer files a complaint? Typically, if there are different areas of the law that they want to address in their complaint, they will address them in what are called counts. So like count 1, count 2, count 3. Each count has a separate cause of action or a separate complaint of alleged wrongdoing by the defendant. So if one or more of the counts get knocked out, maybe one of the counts will survive, which allows the complaint to continue. So I've seen that all the time in my own cases, in my own practice, where defense attorneys try to knock out my case saying it didn't meet the pleading standard and so on and so forth. Many times I lose, I might add, because I used to be that guy. So you want to have several counts in your complaint in order to hopefully have one or more of them survive. So that's why the plaintiff lawyers do it. And also because you want to include as many bases in your complaint as possible to make sure that one of them sticks. So the plaintiff alleges the defendant violated the CLRA by failing to allege the existence of the defective wiring. So the plaintiff's CLR claim, this is the consumer fraud specifically, it's called the CLRA, is the abbreviation for the California Consumer Legal Remedies Act. So it's a specific statute they have for legal remedies when you're dealing with, it's kind of like a quasi-lemon law type remedy. So the court goes on to state that a manufacturer's duty to consumers is limited to its warranty obligations, absent either an affirmative misrepresentation or a safety issue. So the court's saying that Porsche is only liable for what their warranty states. But if there's another situation where there's a safety issue, then it goes beyond the warranty and you could theoretically be on the hook for it. So the plaintiff has to allege sufficiently that a defendant was aware of the defect at the time of the sale to survive a motion to dismiss. Okay, on the issue of duty to disclose, the defendant argues that the defendant had no duty to disclose that a component of plaintiff's car might require repair or replacement after the car's warranty is expired. So warranty's gone and say we don't owe any obligation. I mean, does Ford, let me put it to you this way, does Ford have a warranty obligation with the Model T Ford? No, that was made back in what, 1910, 1912? I mean, yeah, things have worn out on it since that time. I mean, when does this warranty end? Is Ford going to be on the hook for a Model T Ford? I think not. I mean, it has to end somewhere, right? So there has to be a cutoff point. But if the car manufacturer is putting something out in the stream of commerce that's defective at the outset of the construction of the automobile, and then released into a stream of commerce, well, they could be held liable way down the road because there is this defect that they put in there. And if it's even worse, if they knew about it, Ford's Pinto comes to mind with the little 10-cent bladder they could have put in to prevent the car from blowing up. So, I mean, manufacturers can be a little bit devious when it comes to putting a product out because they want to save money. They obviously want to make a profit, but they can't be making a profit at the expense of people's lives. So in the instant case, the parties agree that the allegedly faulty wiring harness in plaintiff's car was not covered by any written or express warranty from the defendant. So they agreed to that. That's fine. Under California law, a manufacturer has no duty to disclose defects outside the manufacturer's warranty unless the defect implicates either an affirmative misrepresentation or a safety issue. So we go to the safety issue here. The plaintiff argues that the alleged faulty wiring poses a safety issue because the wiring defect could cause the car to malfunction while in motion and may cause electrical systems such as the car's headlights to cease functioning at night or in the rain. Although the plaintiff didn't have any personal experience with these malfunctions, the class action complaint includes allegations that the defective wiring could cause the car to become disabled in the middle of a road or highway and could render the car's headlights or other electrical equipment inoperable in the evening or during the rain. So that's their allegation. The court has to weigh in on that. Such malfunctions would affect the car while in use, which amounts to a material safety hazard. Well, the federal court concluded that the plaintiff has sufficiently alleged that the alleged defect in the wiring harness posed a safety hazard that gave rise to a duty to disclose the defect. Porsche didn't disclose it. That cause of action is going to be upheld and it's going to be allowed to proceed. I don't know what the end result was, but we're at the pleading stage here and we're in the motion to dismiss. The pre-answer motion is what it's called, a pre-answer motion. Now, number 2, defendant's knowledge at the time of the sale. The defendant next argues the plaintiff had not sufficiently pled the defendant was aware of the alleged defect at the time of the sale as required to state in the CLRA claim. Defendant argues that any allegations of defendant's knowledge must be pled with particularity pursuant to Rule 9b because plaintiff's CLRA claim sounds in fraud. So plaintiff has alleged fraud, and the requirement is more specific or specificity in the pleadings. Now, the plaintiff's CLR claim sounds in fraud and thus is subject to the Rule 9b heightened pleading standard. So that's the heightened standard that the plaintiff's going to be held to. Otherwise, that's going to get dismissed. Well, the plaintiff's car was first sold on May 27th of 2007. And the parties agree in their briefing that May 2007 is the relevant date for defendant's knowledge of the defect. Let's look into this a little further here. The allegation that the defendant discontinued use of the defective wiring for model years after 2007, including the 2008 model year that was released in 2007, supports the inference that the defendant knew about the defective wiring in at least 2007. Makes sense to me. Defendant also issued a TSB bulletin regarding the defective wiring in January 2008, likewise supporting the inference that the defendant knew about the defective wiring as early as May 2007. Now, the court holds in another case that they cite in this brief that it's reasonable to infer that technical safety bulletins were preceded by an accretion of knowledge by the car manufacturer. So, in other words, what the court's saying is, yeah, Porsche, you issued a TSB, but you're not going to issue a TSB based on one car. You're going to be accumulating information over a space of time. So, I mean, it's not going to be one little space of time here. You got to think four-dimensionally. You're going to go back maybe a year and a half, and there are a number of complaints, so we get to this point here. Well, now you issue your bulletin. Well, it shows in the past you knew about all these complaints. That's what caused you to issue the bulletin. You didn't wait for one car to have the problem to issue the bulletin. So you knew in the past that there were problems when you issued the bulletin. Therefore, you knew about this defect at the time of the sale. So court held that taken together, the allegations the defendant received complaints about the defective wiring before the defendant began selling the 07 model, and they issued a TSB regarding the defective wiring in January of 08, and discontinued using the defective wiring for model years after 2007, that permits the court to plausibly infer the defendant knew about the defective wiring by at least May of 2007. So therefore, the court says the plaintiff sufficiently alleged the defendant had knowledge of the alleged defect in the wiring harness at the time of the sale of plaintiff's car to the plaintiff. And the court goes on with regards to the plaintiff's transaction. The defendant tries to argue that the court should dismiss the plaintiff's complaint for failure to allege that the plaintiff engaged in a transaction with the defendant. Imagine that. They're saying, well, the plaintiff, you haven't shown us that you actually bought the car from us. I mean, it could have been a gift. Believe it or not, that's the argument they made in this brief, that it could have been a gift. There's no showing that it was actually a sale from the defendant to the plaintiff. Now, the court goes on to say that plaintiff alleges that the Porsche disclosed to plaintiff that the class vehicle contained a latent defect that would result in his vehicle being rendered non-drivable when it did, even when equipped with a brand new battery and or alternator. Plaintiff would not have purchased his vehicle or paid as much as he did for it. Plaintiff alleges that the plaintiff and the class members conveyed monies and benefits to Porsche in the form of inter alia, which means, among other things, the purchase price or lease payments for their vehicles and the repair and parts costs for their vehicles to repair the damage caused by the defect at issue. So the court concludes that the plaintiff's purchase of the vehicle satisfies the transaction requirement of the CLRA, even if the plaintiff did not purchase the vehicle directly from the defendant. So as you recall earlier, I believe the plaintiff had bought it from a used car lot. I think it was a used car lot that sold Porsches, obviously. So those causes of action survived. The plaintiff's purchase of his car is sufficient to satisfy the transaction requirement of the CLRA, and the defendant's motion to dismiss the plaintiff's CLR claim for failure to state a claim is denied. So the plaintiff actually goes on to allege fraud under UCL, which prohibits unfair, unlawful, or fraudulent business practices. Just to kind of sum up here, the court also held that the CAC, the class action complaint, states a claim under the CLRA, and the complaint also states a claim under the fraudulent prong of the UCL as deceptive practice. So therefore, the defendant's motion to dismiss under deceptive practices was also knocked out. Now, the plaintiff's final claim was for injunctive relief. The defendant argued the plaintiff's request for injunctive relief, which means to stop the plaintiff or stop somebody from doing something. That's what an injunction typically is. It's called a negative injunction, to stop somebody from doing something. An affirmative injunction is different. It's an injunction that forces or orders a party to do something. So in the injunctive relief that was filed by the plaintiff was denied. The court was going on to say that in order to have standing to pursue injunctive relief, the plaintiff has to allege that the plaintiff faces an actual or imminent concrete harm that has a causal connection to the conduct complained of, and that would be redressed by a favorable decision regarding the injunction. So the plaintiff couldn't show that he was in any kind of immediate harm or danger because of this defective wiring. Look, you just don't drive the car. You know that it's got a problem. Don't drive it. Get a rental, use your wife's car, use whoever's car, but you're not in any immediate harm. Therefore, the court denied the plaintiff's injunction request. However, the court grants the motion for denying the plaintiff's prayer for injunctive relief, but the plaintiff is going to be allowed to cure this defect in the pleading by being allowed to replete it. So that, in essence, is the end of that case as far as I know. It obviously continued as far as the other counts that were alleged, and I think Porsche had a problem with it. I don't know what the outcome. It still may be pending because this is 2016, and it's been my experience with litigation. It's like a marriage. It goes on for a while, but like all marriages, it comes to an end. And I'm actually pleased to point out that that thing you see painted behind me, it survived 3 marriages. They didn't get that car, so I'm pretty happy about that. The car stayed. They left. Marriages don't always work. So, but marriages to files, sometimes they last longer. I don't really have anything more to add at this point, but look forward to future dissertations on my channel as it pertains to anything automotive related. I may the next one up may be a red light traffic case, maybe a speeding ticket that goes up on appeal. It could be a drag race where a part blows off of a supercharger and hurts somebody in the stands. There's all kinds of case law out there in all the states, and I find it quite interesting, and I hope you do too. So this is Richard Elslager signing off. Time to take the gloves off, and I will see you soon. Thank you.